My name is Ivan Alogna. I'm Arthur Watts Research Fellow in Environmental Climate Change Law at the British Institute for International Comparative Law. I would like to welcome you all to this second episode of the BICL Human Rights Due Diligence Forum webinar series on human rights due diligence for climate change impacts. Also, on behalf of the director of the forum, Liz Smith, thank you all for joining us and for your interest in this timely topic. Today, we are going to discuss the intended impact of climate change litigation on corporate due diligence. As already discussed at BICL last January event, Climate Change Litigation Comparative International Perspective, we are witnessing an increasing wave of strategic climate change litigations, traditionally brought against states. To date, we have seen a few cases against companies. Civil claims are often focused on compensatory damages, which, even if awarded, may not necessarily lead to a change in the practice or governance within the relevant company or industry. This panel will consider whether climate change litigation is even intended to have impacts on corporate due diligence, whether there is any evidence that climate litigation have resulted in changes in companies' due diligence practice, and whether we can expect this kind of litigation to increasingly drive corporate due diligence in the future. Also, given the move toward mandatory legal requirements and even more widespread recognition of the climate emergency. Before starting introducing our speakers, let me give a little practical note. As we did last time, we will reserve questions for the speakers at the end of all presentations. So you can write your question at the Q&A button at the right end of your screen. And without further ado, let me introduce our first speaker, Professor Jolene Lin. Jolene is an associate professor at the National University of Singapore's Faculty of Law. She's also the director of the Asia Pacific Center for Environmental Law. Jolene's research focuses on global climate change law, strategic climate change litigation, and transnational environmental law. Jolene is a prolific and outstanding author. Among her most recent publications, we have Governing Climate Change, Global Cities and Transnational Lawmaking, and also Climate Change Litigation in Asia Pacific, which will be forthcoming. Welcome, Jolene. It's a great pleasure to have you here today. You have the floor. Thank you.
Thank you very much, Ivano, and thank you very much for the opportunity to be here. I'm going to share screen first, and we'll be able to continue soon. Wait, what's happening? Okay. All right. So, I'm going to start with my presentation, and I'm going to provide a sort of an overview of some of the trends and in global climate litigation, and then zoom in to focus on an emerging trend of climate change disclosure litigation. So basically, when we talk about litigation and the effects it has on the target actors, the idea of litigation being strategic litigation, oftentimes we see climate litigation being used in combination with other legal and non-legal strategies, particularly social media campaigns and political campaigns, to seek legal and social change. When we talk about climate change litigation, we're talking about a wide range of legal actions, including court proceedings, administrative proceedings, petitions, and prosecutions. And
sorry, Jolene, I don't want to interrupt you. I just wanted to check. We can only see a white screen of your slides. Is it perhaps on your side the same? Sorry.
No, that's not happening on my side. Hold on a second. Stop share, and I'll try it again.
Sorry about that. Thank you.
Okay, no worries. Okay, let's try again. Okay. Okay, we'll share. Is it working now? Okay, great. Thank you very much.
Yeah,
I apologize for that. All right, let's rewind. Very quickly, litigation as a regulatory strategy. So the idea is that climate change is a form of strategic climate litigation, strategic litigation the idea of litigation being used usually in combination with other legal and non-legal methods to seek change. When we talk about climate change litigation, we're talking about a wide range of legal actions, including court cases, administrative proceedings, petitions, and prosecutions, addressing both issues of mitigation as well as adaptation. Now, what we have seen is that there has been a growth in the amount of litigation in the United States as well as globally. The United States is often singled out because of the high number of cases. It's kind of like a super mega jurisdiction. But what we have seen is that we have seen litigation in 29 countries, including the European Union, and in some of the regional and international tribunals. As I said, you have a lot of cases in the US, based on the latest count, 1,213 cases filed in the US, with about 384 cases filed in other jurisdictions. Of course, there is a certain level of underreporting to these numbers. These numbers we rely on the official databases for these numbers, but in my work on developing countries, we find that there are many cases which, of course, do not get reported because of translation issues and the fact that many of these cases, therefore, don't reach the databases. Now, most litigation has involved and continue to involve statutory pathways, particularly in the US. And there is a primary focus on governments, but we do see more cases against corporate actors. Increasingly, we see that there's a sort of a so-called rights turn in climate litigation, by which we mean that increasingly we find human rights arguments as well as constitutional rights arguments being advanced in cases. And I believe the other speakers will speak more to that. And the vast majority of cases focus on mitigation, but there is an emerging body of case law looking at climate adaptation. Now, we talk about climate litigation, there tends to be an assumption that it's always about seeking regulatory action to promote climate action. That is true. Most of the litigation is largely pro-regulatory movement, but there are also anti-regulatory cases. This is just a screenshot from the Grantham Institute's latest trends report. And so you can see here there has been a steady increase in the number of cases up till 2019. Now here, I just like to share with the audience the idea that litigation has both direct effects as well as indirect effects. By direct effects, we really mean what we hope for are statutory interpretation, changing the common law such that you recognize the need to take into account climate change impacts. And of course, constitutional interpretation, the right to life or the right to a clean environment, including the right to live in a stable climate. But there are also indirect effects. What does this refer to? The idea that litigation poses costs as well as risks to business, to governments in trying to continue as per business as usual. Litigation also reflects and seeks to change social norms and values. And therefore, what the indirect effects of litigation seeks to do is to mobilize, the litigation seeks to mobilize change and therefore a corporate response or, for example, a government response. Now, moving on to talk about business climate risk disclosure, I chose to talk about this as an emerging trend because it seems quite relevant to the issues that we're discussing today. Now, there are not that many cases. And so in this, I'll just briefly share three cases that that are examples of how there are these cases now trying to challenge inadequate disclosure by companies of the risk posed by climate change to their business model. And so far, we've seen examples, the US, Europe, and Australia. Now, one of the most high-profile cases would be the ones against ExxonMobil. This lawsuit, for example, was filed by the New York Attorney General, alleging that misleading statements about the cost of future climate regulations to investors meant that ExxonMobil was guilty of legal misrepresentation and therefore in violation of the relevant securities law. The case was dismissed by the New York Supreme Court last December, primarily because the court found that the statements did not constitute a material misrepresentation, and these statements made by ExxonMobil were not likely to significantly influence investors' perceptions about the business risk. There have been similar suits that are being filed in the US, modeled on this idea of going after oil and gas companies for their misrepresentations on the risk to their business. However, I think the high bar really is on the idea of materiality and whether it really affects investors' decisions, and the jury's out there on this still. This is probably a case that most people are very familiar with because it's one of the most high-profile cases in the EU in the idea of in the campaign beyond coal. So basically, this particular power plant was meant to be the last coal-fired power plant to be built in Poland. It was meant to be built at the expense of 1.2 billion euros, and there was a shareholder resolution consenting to the construction of this coal-fired power plant. However, an environmental organization, an environmental law firm, filed a shareholder lawsuit that sought to annul the resolution and to basically to hold that the resolution was invalid. And basically, one of the core arguments behind Klein Earth's case was that the power plant harmed the company's economic interests due to climate-related financial risks. In other words, this power plant would be a stranded asset, and it was not to the country's interest or the company's interest to invest in this, to build this power plant. The case was brought under the Polish Commercial Companies Code, and in August last year, the regional court in Poland found the resolution to be invalid, and therefore this was one of the obstacles in the construction of this coal-fired power plant. Although since then there have been other factors that have stood in the way of this coal-fired power plant, mostly to do with investment decisions by investors that they will not be investing in this coal-fired plant because of the direction being taken by the EU Green Deal. And finally, you have cases against banks, companies, and pension funds seeking to argue that they are being negligent in failing to disclose climate risk to their customers. For example, in Australia, right now, okay, so basically, first of all, there was a lawsuit against the Commonwealth Australia Bank over their inadequate disclosure of climate risks. This case was settled after the bank agreed to include details on climate risks in the annual report. Right now, there are two ongoing cases that are of interest. The first is a case, McVeigh, against REST, which is a superannuation fund. So the superannuation fund is basically a pension fund. McVeigh is like a 24-year-old employee who has been putting money in this superannuation fund and argues that the failure of the superannuation fund to provide pensioners like him information of how they are dealing with climate risks constitutes well, basically it violates their fiduciary duties as trustee. And very recently, in the midst of the pandemic, a law student, Catherine O'Donnell, filed a lawsuit against the Australian government, arguing that the Australian sovereign bonds were being negligent in failing to provide adequate information about climate risks to its investors. So basically, anyone who holds these sovereign bonds is holding something that could potentially be a stranded asset, and this is therefore a violation of its duties. So here I'm going to stop. I just wanted to basically, end on that note, and thank you very much, and look forward to the rest of the presentations. Thank you.
Many thanks, Jolene, for this very insightful presentation, this global presentation. We will have some time for some questions for you at the end. Please, if you have any questions, you can start writing them down in the Q&A window. Now, without further ado, I introduce our next speaker, Annalisa Savaresi. Annalisa is a senior lecturer in environmental law at Stirling University. She's an expert in climate change law, and she's working also in the interplay between human rights and climate change law, with 20 years experience working with international and non-governmental organizations. She has contributed to numerous law and policy reports for international organizations and governments. Lately, she provided technical advice in the context of the world's first inquiry into the human rights violations associated with the impacts of the fossil fuels corporations, what we call the carbon measures inquiry. She's member of the UCN World Commission on Environmental Law. She's director for Europe of the Global Network on Human Rights and Environment and associate editor of the Review of European Comparative and International Law. Welcome, Annalisa. Thank you for joining us. You have the floor.
Many thanks, Ivano, for that generous introduction. As you mentioned, my focus today is going to be on human rights-based climate change litigation. So I'll take you to the next step after Jolene's excellent introduction on the complex subject matter of climate change litigation. There's a lot of it around these days, but my job today is to zoom in, if you like, in the specifics of human rights-based climate litigation. This topic was already addressed at the seminar last week, so I'll try to make my contribution relevant for the perspective of today's presentation. And I apologize for the ambulance that's just driving past this building. So apologies for background noise. Now, as it was already mentioned last week, human rights have come increasingly to the fore after the adoption, and indeed in the lead up to the adoption of the Paris Agreement, because this issue is specifically mentioned in the preamble of that treaty, as you can see on the slide. Since and in anticipation of that, a number of human rights bodies have taken positions on the matter of human rights and climate change, largely drawing attention to the fact, which may sound obvious to many of you, that states' human rights obligations in this area are quite important. And there has been an increasingly large body of intergovernmental documents that try and interpret climate change obligations of states in light of human rights law. And in this connection, there is a lot of literature, and I don't want to bore you with the details here, but you may well appreciate that human rights law and obligations at the national and the international level are relevant as a paradigm for climate action on the one hand, and on the other, as a remedy. So human rights obligations provide, in principle, an avenue for climate litigants, as we will see today, in order to complain about human rights violations associated with climate change. And here's a reference to a couple of papers on this matter. So the Special Rapporteur on Human Rights and Environment last year published the second report that is being dedicated specifically to the matter of climate change. And what is particularly important for today's purposes is that for the first time, the UN Special Rapporteur made an effort to distill what are business responsibilities in relation to climate change. And here's what he had to say. He suggested that business responsibilities in relation to human rights have specific connotations vis-a-vis climate change. And in particular, they entail that businesses should, in order to comply with their human rights responsibilities, reduce greenhouse gas emissions from their own activities and those of their subsidiaries. He also suggests that businesses should reduce greenhouse gas emissions from their products and services, minimize greenhouse gas emissions from their suppliers, and publicly disclose data in relation to that. And finally, quite importantly, they should support rather than oppose public policies concerning climate change and ensure that people affected by business-related human rights violations have access to remedies. And here is what is going on in a nutshell. Jolene has mentioned already there is quite a lot of climate change litigation. Not so much climate change litigation is based on human rights arguments. These are largely non-state actors going against states. However, there have been some cases of non-state actors going against other non-state actors. And in this case, I intend to refer to corporate actors. Last week, the colleagues from Greenpeace were mentioning some of these important cases. And in this connection, it's important to appreciate that this is not always judicial litigation. We're also talking about quasi-judicial processes. And we will be looking at one of these today in the context of the Carbon Mayors Inquiry. So the Carbon Mayors Inquiry, in which I've been involved in a way, as Ivano has mentioned, dealt with the impacts of climate change in the Philippines. What do we mean by that? Clearly, you all appreciate that the ongoing impacts of climate change are already causing harm to the environment, to real estate, and to persons. But how does this translate into human rights complaints? This is what happened for the first time in history with the Carbon Mayors Inquiry. This inquiry was started upon the initiative of Filipino individuals as well as civil society organizations, including Greenpeace. It was brought after a series of typhoons wreaked havoc in the Philippines, and the applicants suggested that the carbon mayors, i.e. global and corporate actors that were not headquartered in the Philippines but were causing the bulk of emissions, were to be held responsible for these impacts of climate change. From a human rights perspective, I reiterate. And in this connection, they invoked human rights that were embedded in the law of the Philippines and in international treaties that the Philippines had ratified. Now, as you may appreciate, when this lawsuit, complaint, we're not talking about a lawsuit technically speaking, because the Philippines Human Rights Commission is a national human rights institution that has the power to conduct inquiries, but is not a judicial body. There were clearly many opportunities here that were associated with raising awareness of an issue, such as the one that I've just described, egregious human suffering and harm associated with the impacts of climate change in the Philippines. Enhance visibility of a question that, as we very well know, is not well resolved by the international climate treaties. And finally, put pressure on state and non-state actors to do more in order to address these kind of problems. At the same time, you probably appreciate the technical, substantial, and existential challenges associated with this type of complaints are enormous. There are questions of jurisdiction and extraterritorial reach of states' obligations, leave alone corporate responsibility. And there are also substantial limits to what you can actually do with human rights complaints such as this. And more existential constraints, if you like, about what human rights law and remedy are for. Are they meant to deal with issues like that? These are the questions that were raised to begin with in 2016 when the Commission started to look at this matter. And of course, a lot has happened since. This is the work that I did together with other colleagues in order to try and understand how these challenges could be overcome in one way or another. And I emphasize I didn't work for Greenpeace in this context. I was working with the Commission when they were trying to figure out the answers to these questions. So the first element is that of transnational operations and human rights responsibilities of business. And here we are clearly looking at an evolving area. This very series is a testimony to that evolution and how fast the law in this area is moving. At the same time, we have judicial precedents that already acknowledge the extraterritorial reach of business responsibilities. So we said in this connection to the Commission, this may not be as outlandish as you think. It's true, it's the first time a question of this kind is posed, but if we logically build on the case law and the other quasi-judicial decisions that have been taken in a number of places concerning human rights, we're not going very far. We are really doing something that's quite logical and builds upon existing practice. With concern to the second question and the issue of causation, again, the petitioners were building upon early scientific reports that have been since corroborated by more scientific evidence concerning the impacts of the carbon mayors on the climate system. And clearly this is suggesting, if we follow what the case law concerning state responsibilities, that it is possible, at least in principle, to argue convincingly that they are responsible, at least since they have demonstrated that they had knowledge of what they were up to and the impact of their activities on the climate system. So in this connection, if you like, the matter is more of that of attribution rather than causation, if we're talking about the technical issues here. And in this regard, joint and several liability schemes have been proposed as a possible way in order to address the issue of attribution to specific actors of specific impact. And finally, demonstrate that there has been a due diligence breach, a breach of the due diligence duty. And here the failure to act on the back of awareness of climate change, as I said, is possibly the trumping card. Now, again, these issues are captured in a paper that I wrote. And I will conclude here with a few reflections on the carbon mayors inquiry, saying that it does provide an important precedent for recognizing that national human rights bodies have a role in this debate, and they are oftentimes the only place to go to complain about egregious issues such as the ones that I mentioned. At the same time, the inquiry is supposed to deliver its recommendations very soon, and the Commission has already anticipated they will find the corporations responsible for human rights violations. And this is the first time this is done in the context of climate impact. So it will be very important to see what repercussions this case has in relation to other cases that were mentioned, for example, last week, like Milieudefensie in the Netherlands, where similar issues are being discussed. Which brings me to my conclusions, and I'll be very brief because I am aware of time. So human rights are being used here as a gap filler, clearly. We lack better specific dedicated remedies to address with liability issues associated with the impacts of climate change. And we are using human rights law and the evolution of due diligence practice in order to address this shortcoming. So what I am saying is that human rights has a role to play here, and it will continue to have a role to play, but in the meantime, we're waiting for more and better and more systemic ways to address egregious impacts of climate change, such as the ones that are at the center of this petition. And I will conclude here, reminding you that the Global Network on Human Rights and Environment has a series on human rights-based climate change litigation, in case you're interested to join that. Thank you so much.
Thank you very much, Annalisa, for this very interesting, precise, and clear presentation. So we pass to our next speaker, Olar Waju Fagbon. He's a professor of environmental law and currently the Vice Chancellor of the Lagos State University in Nigeria. For almost 30 years, he has taught environmental law, and he has served as consultant to government and bodies such as the European Commission and the Global Environmental Facility, and on several environmental bodies at local, national, regional, and international levels. It would be very long to cite all of them. He was a member of the International Bar Association Special Task Force on Climate Change, Justice and Human Rights, which produced the report Achieving Justice and Human Rights in the Era of Climate Disruption, which was published in 2014. Welcome, Larn, and thanks for joining us. It's a great pleasure. You have the floor.
Thank you very much, Ivano, for that beautiful introduction that you've given me. And I want to also welcome our participants to this event. let me say that the focus of our own presentation will be looking at Africa. And I must admit that the presentation by Jolene and Annalisa has provided very robust background for the presentation that I will be making. When you look at Africa and climate change, the global consensus is that Africa is the continent that is more vulnerable to the impact of climate change than any other region in the world. And why is that so? When you look at the frontiers of science innovation, you find out that Africa is still very far behind in terms of the ability to adapt to climate change in tandem that with its own local knowledge, values, and the rest of them. Again, you find out that there is always this lack of will on the part of government to prioritize and act on climate change. And when I look at some of the decisions that we have within the African continent, you begin to see the incoherence in policies, in laws, and in the strategies that are being used. Of course, poverty is large scale, and with food security, Africa is heavily dependent on rainfall. So you see that interconnection between Africa and the climate. And when you see a challenge to the climate, it has very serious negative impact on Africa. So that actually is the background to the problem. So I underline that the importance of climate change litigation in respect of corporate due diligence as another critical approach to meeting the challenge of climate change is particularly when it concerns multinational and transnational companies is very key to Africa. Now let us go to what I've done here is to identify the sources of climate obligations in terms of the regulatory framework. And I've done something here that will just show you that in the context of international law, what are those critical documents that we're looking at? There are documents that we are all conversant with, the UN Framework Convention on Climate Change, the Paris Agreement, which makes it possible for litigants to place the action of their government or corporate bodies into the international climate change policy context. And then, of course, you're looking at the African Charter on Human and People's Rights, which actually consolidates the notion that rights are interdependent and indivisible. And of course, there are a number of cases that has been determined in Africa that underscore that in the context of public interest litigation. Now, in terms of the national laws, what I'm going to show here is what we reflect on Nigeria, but it's actually replicated in almost all the other jurisdictions in Africa. When you look at their constitution, some of them you see justiciability for issues related to the environment. In some of them, it is not even there. In some of them, it is reflected in such a way that you can go ahead to enforce it. Environmental impact assessment is there. But when you look at environmental impact assessment in some of the African countries, you find out that it is probably there just to fulfill all righteousness, that we are also doing it without necessarily taking on board the philosophy of EIA. For those of them that have oil, National Oil Spill Detection, you have it in different variants. The Nigerian Code of Corporate Governance, for Nigeria, you see it in the 2018. For other African countries too, you see it in different ways. Central Bank of Nigeria Sustainability Banking Principles, they also have it in different ways. And you find out that central bank is very critical because of the funding approach that you see. If you don't fund, if you are interested in funding green projects, it will be a lot more easier for climate change. If you are not really focused on funding green products, then that is a challenge. Then again, for the oil industry, you see the environmental guidelines and standards. As I stated earlier, what you see here reflected in relation to Nigeria is also what you see in a number of African countries reflected in their different laws. That takes us to what do you see as the goals and objectives of the regulatory framework in most of these African countries. There are three things that you can look at by way of my submission of what this is. One is to create a legal standard of care that will compel adequate attention to sustainability issues. Then you see they want to turn the sustainable practices to become corporate culture for quite a number of the companies. And then the last one is to underscore the fact that it can be a win-win situation. Responsible corporate governance in the corporate bodies can contribute to successful long-term business. So the fact that you are doing sustainability you are following sustainability approaches will not in any way impact on your profit margin at the end of the day. It can actually be a win-win. Now, it is one thing to talk about the corporate goals. It's another thing to look at how is that playing out in real life. So I asked the question, any role for climate change litigation? When you look at the laws, without a doubt, yes. While there is a role for climate change litigation, you begin to ask yourself, how well are those laws being utilized? What are the things challenging the usage of these laws if they are not being utilized? And these I will talk about in a moment. How about the codes, principles, and guidelines? As we all know, the codes, principles, and guidelines, these are not things that you can enforce because it is more of self-regulation by the industry. But when you look at these codes, principles, and guidelines in depth, you will see that they mandate a number of climate-related sustainability initiatives. Some of the things I identified there: waste recycling, power energy saving initiatives, support for environmentally friendly projects. Then where there is insistence on environmental impact assessments as precondition for projects, you see a whole lot of things playing out. So I tell myself, I stated that when you look at the codes, the principles and guidelines, what you will expect is that gradually they should begin to result in more regulations. Because when they result in regulations that can become binding and enforceable, not just as a self-regulatory thing, but that civil society organizations and NGOs can also occupy that space to utilize them, they will galvanize climate change litigation a lot more. So my own view is that some of these codes, principles, and guidelines, if indeed we want them to move forward, and why do I say this? There was a study that was done by Deloitte on sustainable banking as a driver of growth. And one of the things that came out as the finding of that study is that there are two critical drivers of sustainable activities for corporate bodies. The first one is reputation, and Jolene mentioned it in some ways, and Alisa also mentioned it in some ways. When they look at the effect on consumers vis-a-vis their reputation, it drives them to want to do sustainable activities. The second one there is compliance with regulation. In the bid for their operations not to be negatively impacted, they are willing and ready to comply with regulations. So if you take a step back and you look at these codes as I stated earlier, you find out that where the codes have that toga, the status of enforceability, i.e. becoming regulations, it makes it a lot easier for them to be enforced. And then that takes us to my next slide, where I looked at the success so far with climate change litigation. And here, I have picked out 3 countries in Africa that have actually experienced climate change litigation. You'll be surprised that most of what you have in Nigeria, for instance, are public interest litigation, as opposed to climate change litigation. Climate change litigation is still at the embryo stage. It's just coming up. So what most people still do is public interest litigation. So when you look at the 3 countries that I've identified now, I identified Nigeria. And this is in relation to, and I benefited a lot from some of the materials of Ivano in this area, because Ivano has actually done a lot of work in this field. When you look at the case of Bimri, the case was filed in 2005 by the local communities, supported by civil society organizations, and the goal was to curb gas flaring, which actually, as we all know, contributes significantly to climate change. 2 things that they relied upon in that case. They were looking at violation of rights to life under the Constitution and African Charter. Then they were also looking at compliance with the provisions of the environmental impact assessment. The court in that case held in favor of the applicant. When the court took that decision in favor of the applicant, the judgment was not enforced. Somehow we can say it's a coincidence, but at the end of the day, it may be the more you look, the less you see. The judge was transferred from that jurisdiction. And that signals something, because it's a kind of precedent that will really have snowballed climate change litigation in Nigeria. Shell did not follow up its appeal until 2019. Until date, the judgment remained unenforced. Now the question is this: assuming that judgment was enforced, it will have resulted in reform of the law relating to gas flaring. And that would have had tremendous impact on climate change. Again, it will have been a precedent that will encourage several other activities to come on board. The next jurisdiction that I'm looking at here is South Africa. South Africa has done a lot in terms of environmental protection. And the case I'm referring to here is that of ArtLife Africa Johannesburg against the Minister of Environmental Affairs. Is actually the Tabat-Metsi dispute. What the court had to consider in that case was the quality and form of climate change impact assessment that is required when a competent authority assesses an application for environmental authorization in South Africa. Notwithstanding the lack of express legal obligation to conduct a focused climate change in that case, the court ruled that climate change is a relevant consideration when granting an environmental authorization, and a formal report on climate change impact is the best evidentiary means from an independent person to consider the impact in their multifaceted dimensions. So you see that this particular case in South Africa went a long way to actually show that climate change litigation can be effective. But at the end of the day, we're going to ask ourselves, how is it that so many other cases have not come up since that time? That takes me to the last decision, which is the one in Uganda. And I examine here the Mbambazi and others against Attorney General and National Environmental Management Authority. That case was instituted on behalf of 4 Ugandan minors in relation to the obligations of the Ugandan government to mitigate climate change pursuant to the public trust doctrine. That case that was filed, since the time it was filed up to today, it has not taken further progress. So it was like after the order of the court that the parties should undertake a 90-day mediation process, nothing has happened thereafter. So I ask, what impact on companies' due diligence? From the cases that I've outlined, you will see that in terms of attitudinal change and influence of different sectors, it is very difficult to gauge that there has been an impact on companies because not too many cases have been filed. And we do not have so many cases as for us to come to a conclusion. And I ask again that, what do I see as the challenges? Why many cases are not being filed? What do I see as a challenge in this area? And quite frankly, I see it in terms of there's a short-term approach to energy security, which remains a driving force in many African countries. So it goes back to what I stated earlier. There's a lack of prioritization of climate change issues for many African countries. They look at it and look, let us take care of our energy requirements. Whatever sources that comes to us that is cheaper in the context of oil, in the context of coal, that is what we will do for now. So you don't see that prioritization. And for as long as government is not showing so much interest, it is only civil society organizations and NGOs that can actually robustly try to compel them to take some steps. Then again, when you look at quite a number of laws in Africa, in many of the jurisdictions, you will see that extant procedural issues are still very, very critical. For instance, you still see challenges with issue of local standard when people go to court and the court declares that they don't have the standing to come before the court. In the case of Nigeria, that has changed significantly. There was a case, the Center for Air Pollution Watch against an NMPC. That case was very significant in that it really made clear that you do not have to show any other thing beyond the fact that, yes, there is something that is happening here and that you are interested in pushing the frontiers of it. The same thing with the Fundamental Rights Enforcement Procedural Rules 2009. These two, the rules and the case, they have actually extended the frontiers of the concept of local standard in Nigeria. Other things that you see, that I see as procedural obstacles that are still affecting that is non-compliance with service of statutory notice. That's the one that is mostly at times referred to as the pre-action notice, statute and time limitations, lack of rules of procedure for enforcement of human rights, and then of course, the problem with the status of codes, principles, and guidelines at the end of the day. Now that takes me to the next slide, where I ask, what are the suggestions moving forward? What are those things that I think we should be looking at in terms of our focus? The first one, I think, is lawyers in Africa will need to go beyond the regular public interest litigation approach and embrace the specific goals of climate change litigation. We need to be a lot more creative. We need to be a lot more innovative. And we need to challenge the status quo a lot more, notwithstanding what will be the issues. Some of these things, even when the courts overrule these cases, some of those things may be the reason why we will continue to focus attention on it and people will come back to it. A second thing is there's a need for the judiciary to be more innovative in the drive towards climate change sustainability. And when we are looking at it, part of what the court should look at as part of innovation and for it to be creative is impact assessment, intergenerational justice, precautionary principles. All of these things are interrelated when it comes to sustainability issues and climate change issues. They are interrelated and they should not see any disconnection with them in interpreting them. And that was the kind of thing that the judge in the Bimre case did. But unfortunately, it was not enforced and we're not able to move forward with that. Then there's a need to evolve engagement strategy between civil society organizations and regulators to deliver better on outcomes of the regulatory process. That is, CSOs can actually legitimize the knowledge in this area and push the frontiers of it. And finally, efforts must be made to deepen support for credible CSOs and NGOs in their interface with local communities. Once again, I want to thank Lise and Ivano for the opportunity of this presentation. Thank you very much.
Many thanks, Larne, for your very interesting presentation on Africa. By the way, concerning the topic of climate change litigation at BICL, we are publishing soon an edited volume with the other colleagues, which will take into consideration global perspective on climate litigation, where Sam Adelman and Tracy Lynn Amby have contributed with 2 outstanding chapters on Africa in national and regional perspectives. You will see in a few months from Real. Our next speaker is Steen Franken. Steen is a partner at Nauta Dutil. He is specialized in product liability, new risks, insurance law, as well as law of damages. He successfully defended Dutch and UK insurers in a multi-billion euro US asbestos claim, the British and also British American Tobacco in the first ever Dutch tobacco claim. Steen is presently representing insurers in mass claims pertaining to the United Linked Life Insurance and advising on the coverage of various large direct liability claims. Steen, I'm very happy to see you here. Thank you very much for joining us. And now you have the floor. Thank you.
Thank you very much, Ivano, for your kind introduction and having the opportunity to speak with you about climate litigation. I'd like to share 3 observations with you.
Sorry, before you start, I just wanted to interrupt you. We see the speaker's view. We don't see the particular slide. I don't quite know how to fix that, but so we see the slides, but perhaps Bart, if you could just mention how to fix the presentation of it. Sorry.
Wait 1 second.
Sorry. Is it possible to stop the sharing and just start it again? I don't know if that'll fix it. Sorry, Stan.
No, that's fine.
We did see it, so if it was just split into the different slides, but it doesn't work. We can just go ahead as is.
Otherwise, I do it without the slides.
The slides are really great, so it would be good if you could try again.
Okay.
One more time. Sorry.
Shall I wait? Yeah.
No, you can upload them again. If you could try with
screen sharing.
Screen sharing again. That would be great. Thanks. Sorry about that.
Does this work now?
Now it's correct. Thank you so much. Sorry about that.
Thank you. So my first observation, I guess, is an obvious one, but important by way of prelude. Climate change is a true revolution. It's not only about new technologies, opening up new opportunities or newly discovered sources. Climate change is first and foremost about scarcity and the urgent need to adapt and to redistribute the limited and scarce resources we have. As a consequence, the re-evaluation or transformation of our traditional values into a new, commonly shared equilibrium. As Jolien Lin indicated, it's a true Umwertung aller Werte, a French revolution which, like the glorious one in the UK, ideally will develop as smoothly as possible. My second observation is about an important distinction we need to make in order to understand that revolution. I believe we need to distinguish between two types of responsibilities. One is the duty of care, to anticipate foreseeable risks on a case-by-case basis and to take precautionary measures if the probability and the kind of loss requires a person in a specific case to do so. The Milieudefensie claim against Shell is based on Shell's duty of care. In essence, Milieudefensie, the Dutch chapter of Friends of the Earth, claims Shell acted and still acts negligently by contributing willingly and in a relevant way over a very long period to the present and future climate change. One of Shell's main defenses, however, is that Shell is operating in a worldwide market with a huge energy demand, and that Shell can individually change neither the demand nor the supply by just stopping producing oil or gas. Such emergency brake would even have a disruptive effect on its interests and the interests of many others. Shell alone cannot change the market rules in order to save the world. Shell's defense, I think, refers to another type of responsibility, and that's the responsibility to redistribute or to attribute, to abide by the rules and to take the consequential responsibility simply because the redistribution rule has been broken. For instance, if we apply rules like traffic lights for every person, irrespective of their specific circumstances, or if we redistribute damages on a strict liability or no-fault basis, just in order to avoid disproportionate free riding, which will automatically require disproportionate sacrifices by others. The agenda claim against the Dutch government essentially was based on this. The strongest defense of the Dutch government was undoubtedly that the requested Dutch greenhouse gas emission reduction per 2020 had a negligible and insignificant impact on the worldwide risk of climate change. Positioned as a duty of care case, Urgenda's request to the court had little weight against the democratic decision of the Dutch government, effectively to free ride on the emission reductions by larger EU countries such as France, the UK and Germany. The Supreme Court nevertheless allowed Urgenda's request and ordered the Dutch state to reduce its emissions accordingly to international agreed standards and human rights. And rightfully, distribution rules are the outer limits of the individual freedom and apply irrespective of the individual consequences. Everyone should stop for a red traffic light, even if there's no traffic visible. I believe the difference between prevention and distribution or attribution has a significant impact on the meaning of corporate due diligence and climate change litigation. And I will illustrate this by way of my third observation. If we want to prevent damage to occur, due diligence helps in explaining how damages can or should have been prevented in a specific case. Reporting serves the purpose of individual accountability. It helps us, for instance, to prevent a serious violation of human rights, because we all more or less know beforehand what is meant by such serious violation. However, if the due diligence serves the purpose of reaching a fair distribution, information how such allocation can be realized is often either less relevant, you better practice what you preach, or just not available. What is a fair distribution in a specific case? Particularly in a new area as climate change, clear rules or guidelines are often not available because we simply do not yet know what we believe a fair distribution to be. Privacy, internet, climate change, they are just the newest examples of defining the traffic regulations as we did about 100 years ago. Information and the preceding due diligence do not serve the purpose of prevention. It serves the joint interest to reach commonality on what a fair distribution could be by explaining not why, by not explaining how, but by explaining why an individual company believes it made a responsible trade-off. In 2017, various NGOs filed an OECD complaint with the Dutch National Contact Point against ING, one of the largest Dutch banks, for not measuring, targeting, and publishing about its total carbon footprint in line with the Paris Agreement. Many meetings, also with experts, followed. ING was able to explain during those meetings its new Terra approach to help steer its lending portfolio towards meeting the Paris Agreement's well below 2 degrees goal. The notifying NGOs, however, believed that ING and the Terra program should move from the 2 degrees scenario towards a 1.5 degrees scenario. And ultimately, all parties decided to call directly upon the Dutch government to request the International Energy Agency to develop as soon as possible 2 1.5 degree scenarios, one with and one without a carbon capture and storage, that would provide a 66% chance to limit global warming to below 1.5 degrees. In explaining why, self-regulation can be key. Redistribution needs a broad social basis. Such basis requires sufficient awareness and transparency. It's therefore crucial that each and every individual stands up, speaks out as much as possible about its interests, risks, and trade-offs. Only then a resilient process of redistribution can be achieved that will help the transition of values into a new, generally accepted package of rules for distribution. Ideally, self-regulation operates as a risk management model, as we see in other high-risk industries, aerospace, pharmaceutical companies, as a matter of just culture. Not about blaming, but about learning from disagreement or so-called mistakes in order to reach solid commonality on what a fair distribution is. This year, a new OECD complaint was made against ING concerning the corporate lending to large-scale palm oil producers and traders. This complaint was accepted since the decision to further examine this specific instance does not entail substantive research or fact-finding, nor does it entail judgment. And the National Contact Point believed it could help to interpret due diligence guidance for responsible corporate lending and securities underwriting with regard to the aspect of shifting from the direct linked category to the contributing category. In the learning process of uncertain risks, the liability of individual companies is far from evident. Traditionally, judges are cautious and will only step in if the specific behavior is either recklessly negligent or if the specific situation is clearly disproportionate. In the Urgenda case, the Dutch government ultimately lost the court's sympathy, since in every instance the Dutch state was not able to explain in a very least credible way why it should be allowed to free ride on larger EU countries. Nevertheless, in specific circumstances, litigation can help the learning process in finding a new balance in society. Questions of distributive justice are generally left to the public debate or political arena. However, privacy, internet, climate change, they show us the urgency to turn to the more distributive questions in private law as well. For instance, via human rights, as illustrated by Annalisa before. The reason often being the essence of time and the political or social inertia. Again, the Urgenda case serves us with a shameful Dutch example. It took 7 years of fierce litigation. The OECD complaints illustrate that a publicly reported mediation is quicker and potentially more effective in reaching understanding and agreement on a new fair distribution. With respect to climate change, we cannot afford that the outer limits of individual responsibility are being neglected systematically. 10 coming years will be crucial. Either we change or not. And if not, the consequences will most likely be devastating for the many generations to come. Thank you very much.
Thank you very much, Steen, for your very interesting presentation and also for your work. We are introducing our next speaker, is Holly Stebbing. Holly is a commercial litigation and dispute resolution lawyer based in London. Her practice focuses on disputes in the energy, infrastructure, and natural resources sectors, both domestic and international. She has a wide range of experience, including litigation in the commercial court, technology and construction court, chancery division, and appellate courts, and all sorts of ADR and incident response. Holly has been tracking climate change litigation developments globally for a number of years and is leading the firm's response to this new and novel area of litigation. Welcome, Holly. Thanks for joining us. You have the floor.
Thank you, Ivano, and thank you for the opportunity to speak on today's panel. I've been asked to focus in the 10 minutes that I have on the corporate perspective on climate litigation and human rights due diligence. As Ivano said, I'm actually a dispute resolution lawyer in private practice, so I cannot say that I'm a spokeswoman for the corporate world. However, in my practice, which focuses on energy and infrastructure disputes, I obviously work closely with corporates. And in preparing for today, I've had the opportunity to consider some of the factors which they may be thinking about when it comes to this challenging topic. I've also been greatly assisted by the report published by Bickel earlier this year and the data, which is very useful, contained therein. So I'm briefly going to cover 3 points today. First is a kind of general corporate perspective on climate litigation to date. The second point is the relationship between climate litigation and due diligence for climate change impacts, if any. And then finally, some factors that corporates may be taking into account when it comes to the pros and cons of mandatory due diligence for climate impacts and what they might expect a mandatory law to look like. Let's see if I can change slides. There we go. So we've heard today about the growth of climate litigation over recent years and how the type of claims issued by claimants has changed and developed over time. In the first wave, we saw claims primarily against states to mandate them to do more to prevent and mitigate climate change. Claims against corporates were rarer and typically focused on tort and public nuisance causes of action, which, as we've heard, faced real hurdles to success when it came to justiciability, causation and attribution. I think at this stage, many corporates, particularly those outside the energy and infrastructure space, did not consider that this type of litigation posed a material risk to their business. There were the obvious reputational concerns and the time and cost of defending claims, but perhaps a general feeling that they were unlikely to succeed. In my view, that perspective will have changed over recent years with the rise in claims targeting companies and also the shift in focus to claims based on human rights breaches, corporate law, consumer protection rules, planning and environmental challenges, and fraud and disclosure claims. These claims have had demonstrable success in some jurisdictions and also go beyond the prospect of damages payouts for historic contribution to climate change to having a real and immediate impact on corporate day-to-day business. For example, some claims are seeking orders imposing mandatory and deep reductions in corporate greenhouse gas emissions. And Stein touched on the Milieu Defensie case against Shell. Other claims are directly or indirectly disrupting the development of new products, which claimants do not consider align with the Paris Agreement, A good example of that is the successful challenge to the construction of the third runway at Heathrow Airport. And more generally, critical access to capital is tightening for corporates with large carbon footprints. So how does mandatory due diligence on human rights fit with this climate litigation picture? I've been interested to hear the various takes today. My initial view was that the two were really separate issues, and it was not obvious that the objective of claimants in climate litigation cases to date was to bring about mandatory due diligence. But I think that it's actually a bit more nuanced than that. Different claimants have obviously had different objectives, but broadly speaking, they fall into two categories. Those who have been looking for monetary compensation for climate-related harm, and perhaps more relevant to today, those seeking orders to compel action by corporates to tackle climate change. And in relation to that second objective, driving change, litigation is obviously one way of doing that, although I think, as we've heard today, it's probably had mixed success. But mandatory due diligence may be another, and I do think the two are linked. Without climate litigation, getting critical corporate buy-in to the introduction of mandatory due diligence laws may have been difficult. Corporates respond to risk, and for large carbon emitters at least, climate litigation is now a real risk for the reasons I've just mentioned. And naturally, they'll be looking to mitigate that risk. And actually, due diligence, depending on its form, can be a mechanism for doing that, particularly where demonstrating that you have complied with due diligence obligations constitutes a defence to claims. And this seems to me to be one of the reasons why some corporates, although I must not say all, are now in favour of a mandatory due diligence law being introduced. Whether procuring corporate buy-in to mandatory DD was a conscious or specific objective of claimants in climate litigation, I do not know, but it certainly aligns with the wider objective of galvanising change. Moving on then to some of the factors that corporates might be considering when it comes to a law on due diligence for climate impacts. And I'm limiting my horizons today to a European-wide law. The concept of human rights due diligence is obviously not a new one, and I think the corporate world, broadly speaking, is familiar with the UN guiding principles and the OECD guidelines, together with the various soft law mechanisms which call for corporates to undertake due diligence on human rights issues. They'll also be more or less aware of the legislative measures which have been implemented more recently on issues such as deforestation, modern slavery, conflict minerals, and so forth, together with the more general French duty of vigilance law. But as noted in the Bickel report, the concept of DD for climate impacts has not been as well explored, and with the EU having announced plans to implement legislation requiring businesses to carry out due diligence, that discussion is now essential. For corporates, I think there will be some appeal in a mandatory due diligence law. First, it promotes harmonisation, at least across the EU, at a time where there is a risk of member states taking individualistic action and corporates being left facing a myriad of different standards to comply with. I think it will also help give some legal certainty as to the standard that corporates will be held to. Just going back to Stein's point on the standard of care. At the moment, I think there's significant uncertainty about what that standard of care amounts to, and therefore what corporates need to be doing to discharge their duties and reduce their litigation risk. A piece of this is the extent to which due diligence can be used as a defence. I think corporates on the whole would advocate that due diligence should be able to be used as a defence or safe harbour to climate related claims, so that where a corporate can show that it's undertaken adequate, appropriate, whatever the standard may be, of due diligence, that can be a defence to a claim of a human rights breach. For corporates who are front runners, legislation obviously pulls others along and creates a level playing field in the market. helping to ensure that business shares in the corporate response, and perhaps also assisting with conversations between customer-facing corporates and their supply chain, who might not be as quick to see the benefits of due diligence as their buyers are. Carrying out due diligence can obviously also enhance your brand, improve your reputation with consumers, and is increasingly something that is required by investors. That investor piece to me is critical. Companies need access to capital, and we're seeing not only shareholders but also financial institutions calling for action and threatening to withdraw lines of capital if that does not happen. And for those working in corporates and charged with sustainability issues, it's probably easier for them to get into the C-suite decision makers where there is binding legislation rather than soft law instruments. But I think corporates may also be cautious about mandatory due diligence for a number of reasons. I think there needs to be an appreciation that this is different to some of the forms of mandatory due diligence we've seen to date. It's not so much the giving of information to shareholders and investors so that they can make decisions about where to invest their money, but really a tool to compel companies to take more positive and wide-ranging steps to mitigate and prevent climate change. And that is a much larger mandate for any legislation, and therefore needs to be given careful consideration. There seems to be a general view that if it's not pitched right, due diligence can end up becoming just an administrative burden focused on box ticking and not really on outcomes, and therefore ultimately it fails to meet its objective while still requiring corporates to go through the process. And I talked in the advantages about the level playing field effect, but obviously if the law is only EU-wide, there's the risk that other major jurisdictions will not keep step, and I'm thinking of US and China in particular in this respect, and that will lead to a loss of competitive advantage for European businesses. Similarly, I think that businesses will be interested in the sanctions which accompany any law. There are always good actors who stop at the red light and those who do not. If legislation is introduced but not enforced, that level playing field advantage falls away. And I think that has been a criticism of, for example, the UK Modern Slavery Act. And if due diligence is to amount to a legal standard of care, corporates will want that to be clearly defined, particularly if the route to recourse will be directly in at parent company level. And I suspect they'll be looking for some flexibility depending on the size of company, the nature of its business, the likelihood of harm, severity of harm, and so forth. There is also an argument that in fact mandatory due diligence will increase climate litigation, not only for companies who don't comply, which would probably be justified, but also against those companies who, by complying and providing details of their climate change impacts and the steps that they're taking to address those, may therefore be targeted by claimants, both the impacts that they have identified or by it being said that they are not doing enough. And I think that would really be an unintended consequence of any due diligence law. Just to conclude, I mean, overall, I think it's obvious that due diligence in whatever form it may come in has to be part of a wider suite of measures, which includes action and more action at state level, and potentially states using their trade arms to ensure that standards are adhered to outside of the EU rather, as a condition of doing business here. So that's just a little food for thought for the wider debate. Thanks, everybody.
Thank you very much, Holly, for your critical perspective. Very, very important for our discussion. Now I introduce our next speaker. I'm really sorry because I think we are a little bit late, but we'll try to keep so I don't know if we will have time for Q&A this time. So I see that already the contributors, the speakers, started to answer the questions. So you can continue to pose the questions, and they will answer in the Q&A. So I was introducing our next speaker, Sudhanshu Swarup. He's a barrister practicing commercial arbitration and public international law. He's in chambers at 20 Essex in London. Sudan shows public international practice has involved some of the leading cases of recent times, including on immunities, law of the sea, and international human rights. Sudan's commercial arbitration practice includes, among other, a lot of other fields, energy and natural resources. He has particular experience of group and tort claims against multinational corporations, having acted in several of the important English cases. And very interesting is currently acting in a claim against Australia in the United Nations Human Rights Committee, challenging Australia's record on fossil fuel emission and seeking remedies to protect the now famous Torres Strait Islands from rising sea levels. Welcome, Sudhanshu. It's a pleasure to have you here with us.
Okay, thank you. Thank you, Ivana. Can you hear me okay? Okay.
Yeah.
Thank you. I will focus on the law of tort. Specifically, does the law of tort require corporations to exercise duties of care or due diligence in relation to climate change? I want to address that question by focusing on the intriguing judgment in Smith against Frontera, which was handed down by the High Court of New Zealand in March of this year. In that case, the plaintiff, Michael Smith, was of Maori descent. His claim related to sites of particular cultural and spiritual significance to him, which were close to the coast or on low-lying land and which were at risk from the effects of climate change. Mr. Smith claimed against various defendants who operated facilities that emitted greenhouse gases, including dairy farms, a power station, and an oil refinery. He alleged that the defendants' contributions to climate change made them liable under the tort of public nuisance, the tort of negligence, and thirdly, for breach of a novel duty, which he described as a duty to cease contributing to climate change. The High Court of New Zealand dismissed the first two claims, but allowed the third novel claim to proceed to trial. As regards nuisance, the court concluded that Mr. Smith could not demonstrate public nuisance for various reasons, including that the alleged harm was not the direct consequence of the defendant's actions. The court put it as follows: Mr. Smith does not and cannot plead that, but for the defendant's activities, he would not suffer the claimed damage. As for negligence, Mr. Smith alleged a duty of care owed by the defendant, quote, to take reasonable care not to operate its business in a way that will cause him loss by contributing to dangerous anthropogenic interference with the climate system. Just pausing there, one can immediately see that if a court recognizes that kind of duty, what the ramifications would be for corporates in New Zealand and indeed around the world. However, the court dismissed the claim, holding that none of the conditions for establishing a duty of care in the tort of negligence were satisfied. In particular, the court held that the damage claimed by Mr. Smith was not a reasonably foreseeable consequence of the defendant's acts or omissions. The court said, the defendant's collective emissions are minuscule in the context of global greenhouse gas emissions. Put another way, the proportion of damage pleaded that is caused by climate change effects contributed to by each defendant is impossible to measure. There was a further point here. The court said that it was not fair or just to impose a duty of care, as this would give rise to issues of indeterminate liability. The court said, in a very real sense, everyone is a polluter and therefore a tortfeasor, and everyone is a victim and therefore a potential claimant. If a duty of this kind alleged were recognised, every New Zealander would be liable to suit from every other New Zealander. However, as to the third, the novel claim, the court allowed this to proceed to trial. Mr. Smith framed the claim as followed. He said that the defendant corporations owed a duty to cease contributing to damage to the climate system, including the dangerous anthropogenic interference with the climate system and the adverse effects of climate change. The court whilst it did not recognize this, it said that the claim was arguable and should proceed to trial, so a trial judge could consider the point properly. The judge said, the common law must be developed to meet changing economic conditions and habits of thought. It may be that a novel claim such as that filed by Mr. Smith could result in a further evolution of the law of tort. It may be that climate science will lead to an increased ability to model the possible effects of emissions. These are issues which can only be properly explored at trial. And finally on the case, just a word on remedies. The court said Mr. Smith was not claiming damages, he was claiming an injunction requiring each defendant to produce or cause zero net emissions from its activities by 2030. And I'll come back to this point at the end, but in essence, the court said it is very difficult to envisage any court granting that kind of injunction, because you're basically asking a court to devise a bespoke emissions schedule, a bespoke emissions plan for a corporate, and that's just not the kind of thing that courts do. So against that background, having set out the case, I just want to make six brief comments. First, significance. This is a significant decision. It is, as a common law decision of a common law court, it would be relevant in other common law jurisdictions, obviously not binding, but it would certainly be relevant, for example, in the US, the UK, India, Australia, and Canada. The principles I've just discussed will be familiar to any common lawyer practicing in those jurisdictions. Second, the science. It was common ground in this case that the science was as set out in the most recent IPCC report. So that the judge said, all admit the IPCC reports record current scientific consensus as to the nature, effects, and mitigation requirements of climate change on a global scale. And indeed, the court proceeded on the basis that climate change is the most pressing issue of this age. So in other words, for all the heat generated in the media about climate change denial and so on, in the cold, hard reality of the courtroom, it is science and reason that seems to be irresistible. Third, knowledge. Knowledge is the essential condition for any duty of care or duty of due diligence to be established and breached. Unless the defendant can be proved either to know of the relevant risks of climate change or should be deemed to know the relevant risk of climate change, that defendant cannot be held to be liable for failing to address those risks. And that's fundamental in all tort litigation, including some of the cases I've been involved with. And again, crucially, in this case, that was all common ground. The court held that Mr. Smith argued the defendants knew or ought to have known since at least the release of the IPCC's fourth assessment report in 2007 that their activities were contributing to dangerous interference in the climate system. That proposition was not seriously challenged in the case. And arguably, one could push the date of knowledge back well before 2007, given the IPCC framework has existed since the 1990s. Fourth, causation. Underlying much of the reasoning of the court that I've summarized was the notion that these particular defendants made a minuscule contribution to climate change, which was, quote, impossible to measure. But an interesting point of comparison here is the German case, Luya versus RWE, which is being brought in the German courts by a Peruvian farmer, Mr. Luya, who is suing RWE, Germany's largest electricity producer, amongst other things, under the claim of nuisance. Mr. Luya argues that RWE has knowingly contributed to climate change and bears some responsibility for the melting of mountain glaciers near his town. Crucially, Mr. Luya argues that RWE's contribution to climate change can be specifically measured based on attribution science, and he puts the figure at 0.47%. And so he seeks 0.47% of the costs of dealing with these melting glaciers. So the point I derive from this is it may be that in future cases, the tort analysis would be different if you had a different set of defendants who, like RWE, were amongst the world's largest fossil fuel emitters, such that it cannot be said it is impossible to measure your contribution. Rather, there's a scientific basis for measuring that contribution. Fifth, as I said, the novel claim was allowed to go forward. And to me, this shows a very important point about litigation in general. Judges do not exist in hermetically sealed laboratories. They exist in a public culture. And I suggest that if this very case had come in front of this very judge maybe 15, 20 years ago, that third claim would not have gone forward to trial. But the point is, judges respond to the public culture. And I think the idea that this very novel general claim was allowed to go forward is an illustration of that. And sixth and finally, I want to say something about the judicial role in all of this, the judicial role in defining the scope of a duty of care or duty of due diligence. I mentioned that Mr. Smith was seeking an injunction requiring each defendant to produce or cause zero net emissions by 2030. And the court said, look, we as judges are just not equipped to do this. And the court went into this in some detail. The judge said, the injunction sought by Mr. Smith would require the court to apply an emissions accounting methodology to determine gross emissions from each defendant. The court would have to select a methodology to apply to carbon dioxide equivalents so that greenhouse gases could be meaningfully compared. The court would have to determine whether an emissions trading type scheme should be required by any court order, and if so, how and to what extent units would be acceptable offsets. The court would have to consider what, if any, trajectory of net emission reductions each defendant would be required to achieve between 2020 and 2030, and so on. And these and other tasks make it extraordinarily difficult to craft any form of injunction. Pausing there, I can fully understand the judicial unease at basically being given a blank piece of paper and being told to craft this injunction for these different corporations, delving into the detail of what these corporations do in their daily business. But again, an interesting point of comparison is the litigation going on right now in France, the duty of vigilance cases against Total. So in one of those, Notre Affaire à Tout and others against Total, there's a claim under the due diligence law. But as I understand it, rather than requiring a court to start with a blank sheet of paper and craft an entire set of due diligence standards for a corporation, as I understand it, the primary relief there that is sought is an order requiring Total in the first place to create the scheme, which I then assume would go back to the court for assessment. And I suggest that kind of exercise, i.e. being given something discrete and concrete, and then being asked to assess that against a standard of reasonableness or due diligence, is something that's much closer, certainly to the sort of exercise common law courts do in more normal tort claims. So in conclusion, I suggest that there is certainly scope for duties under tort to be applied to corporations, but how this area of law develops will depend on the particular defendants, the particular facts, and perhaps ultimately the particular judge that the case ends up being heard in front of. Thank you.
Thank you so much for your presentation, Sudhanshu. Sorry to everybody for running late, but I'm sure you don't want to miss our next and last speaker, Ingrid Goodbay. Ingrid is the head of the Human Rights and Environmental Disputes at London office of Housefield Global. She has been a litigator for over 24 years, and she's recognized for her work in a number of groundbreaking cases in both Australia and the UK. Recently, she acted as co-counsel together with the NGO Earth Justice in the first petition submitted to the UN Child Rights Committee on behalf of 16 children. I think that you heard about this, drawn from variously climate-affected regions of the world against 5 G20 countries. Ingrid's work is mainly focused on domestic international climate emergency case and related high-level policy development. To finish, she's also a trustee of 3 social enterprises, including one based in the Netherlands, which trains and empowers youth to become sea rangers to work with European government fisheries to stop, monitor illegal fishing in the Mediterranean and Baltic seas. Welcome, Ingrid. It's a great pleasure to have you here. Thanks for joining us. You have the floor.
Thank you, Ivana. again to Bickel and to Lise for inviting me back. You just can't get enough. I can't get enough. This has been a very interesting panel, and I have to say a very well informed panel. And many things I was going to say have already been said. This is the wonderful thing about being last. So I have had to rejig things as we've gone along. Very well outlined. But I'm going to make just some headline observations really that have come out of what has been said today. And of course, in my experience and observation in the last 10 years in the climate space, 5 very actively in litigation. Before that, the lead up and build up to those cases. The first thing that comes across very loud and clear is the uneven nature and ad hoc nature of the work across the world. The judicial approaches, the types of and nature of cases being brought. And while we sit here in this bubble and look at these cases and think they're bigger than Ben-Hur, and there seems to be a lot of them, in fact, they're a tiny drop in the ocean, as we all really know. So let's get some perspective on really what is the litigation, how much of it is it, and how much impact is it actually having. So to get to the impact side of it, I think there has been a lot of ad hoc litigation in the human rights world, clearly because the Paris Agreement did not assist with sort of enforceable, justiciable actions. So we look to the human rights world largely in the beginning. So the last 5 years, we've sought remedies through human rights. Now, of course, we're on a cusp, a very exciting time where we're moving into competition, commercial company law, where duties are hardening in various ways, whether it's directors' duties, fiduciary duties. Competition is now looking hard at energy infrastructure and monopolies in Europe and elsewhere. So I think we'll see some fairly exciting things, which are all going to be informed through CC. Certainly within this firm, the competition and commercial teams are alive to the climate change opportunities that might be on the horizon and are currently being put to us. So that is true. I think Holly's presentation really very interesting, because really looking at due diligence, what it is, what it might be. And we've got this, we have this sort of what looks like a very tantalizing pledge from the EU, saying that there will be remedies, there will be sanctions, there will be things that we've been seeking in the new EU regulation coming on stream next year. It's difficult to know exactly what that looks like, but we can assume from previous due diligence activities, particularly in France, that a lot of it will be or could be again voluntary based, and as Holly rightly said, if companies and corporates are able to say they have met a certain standard within the due diligence, that may well act as a defense to any further liability. That, I think, would be a tragedy for all of those people who've worked very hard on the due diligence side and to make mechanisms work against corporates. So it is extremely important, and I know Olivia De Schutter has been speaking about this very much around the world, that we separate legal liability and the opportunities for litigation from due diligence. I think that is going to be an important headline as we move forward, that there is an extreme danger of generally looking at tick boxing. It may be called meaningful, but tick boxing anyway is an exercise, and that we will then fall away tragically into due diligence. I think it's important to say that the UN recently, I was invited to a session of ambassadors from vulnerable states who are advocating very hard, along with David Boyd and others, for a separation from environment and climate change. So climate change being seen separately in a new mandate of human rights and climate change, then being indivisible. It is seen that the current situation of human rights and environment, the mandate is so broad that it cannot possibly provide the guidance required or the clarification required to states, to corporates, to civil society, to stakeholders, that the new mandate and a resolution will be forthcoming to put that mandate will offer the opportunity for greater clarification, greater oversight, and greater dedication to this area. And I think there we will see some impacts coming through, hopefully sooner rather than later. As Dean rightly pointed out, we have the 10-year turnaround, and up to now, litigation and all its initiatives around it, relatable, have taken an incredibly long time. So we really need to get this show on the road. And I think the UN now is starting to gird its loins to mainstream this throughout all bodies in its work. The Human Rights Council has come out, or certain people, individuals from that. There is no consensus within the council around climate change. And I think that is the status around the UN. So it's extremely important that from the top, we start getting more clarification guidance. They are seeking more civil society support for that mandate. And from the bottom up, obviously we've seen civil society coming out massively. We've acted for many youth and children who are now advocating. They are now moving into all sorts of what could be said legal or litigatable type of areas, including writing open letters to governments, pre-action protocols. The children that we represent currently before the UNCRC, who are now greatly empowered, have formed their own hub, are writing to Norway, are writing to Poland, are actually setting up frameworks for liability through notice to governments. And what they are attempting to do is, of course, introduce more legislative frameworks for corporations. As Holly and others have rightly pointed out, the companies can still rely on that old chestnut of uncertainty to not do anything. It may be legitimate to a certain point, but we have had, just in our experience, contact with a number of climate change risk managers within banks who've contacted us, saying, you know, they've accepted a poison chalice and stepping up to the management here, where their reports are ignored, where they're finding that they're isolated within the corporate structure, and no one really wants to take much notice of what they have to say. I think these things are all very important because within corporates, they need more support. These people who have taken on these, there need to be more support networks for those people who are working within the corporates. There needs to be more guidance, clarity from the top down to corporates and states. And there needs to be more engagement, as there quickly is a growing engagement from civil society coming up from the bottom. And as for us lawyers, we need to be listening to all of them. And as has been said by Steen and Holly and others, we need to be extremely creative with what we're hearing and reading, and we have to ride with the wave very quickly indeed. Thank you.
Thank you very much, Ingrid, for this very interesting presentation. It's been a perfect conclusion. Apology, we are 9 minutes late. Apology for taking up more of your time than expected. I hope that you have enjoyed this episode as much as I have. We are waiting you next week on Thursday at the same time for next episode of our webinar series. We will discuss some mandatory human rights due diligence laws. What are their implications regarding corporate climate change impacts? Thanks again to everybody, to our excellent speakers, and to you all for joining us today. See you next week.